I would like to note that it's rather timely now that it is National Crime Victims' Rights Week, and I think it's only appropriate that we would bring forth an issue that really allows the victims of crimes to be able to achieve justice in a quicker way. I want to take a moment just to explain how the death penalty appeals process works now. There is, of course, the trial, then there is the separate sentencing phase of the trial, and after someone has been sentenced to death, there's a circumstance where automatically that sentence and the trial appeals are taken to the Supreme Court. My bill won't affect that in any way. The Supreme Court will have an automatic review of all death penalty cases. The problem is that after the Supreme Court has ruled, we have something called post-conviction litigation, where the person that has been sentenced to death comes back to the trial court and begins filing motions to attack their conviction. What we've learned, and we took hours, Mr. Speaker, of testimony and hours of research in the Criminal Justice Subcommittee, is that that post-conviction litigation process creates excessive delays in the state of Florida. As a matter of fact, of the around 400 people that we have on death row in Florida, as a result of our broken post-conviction litigation process, we have 155 people who have been on death row for longer than 20 years. The only state in America that has more people that have been on death row longer than Florida is the state of California. So that's how the process works. I'll walk now through some of the elements of the bill that I believe will fix that process, protect due process, but at the same time end these frivolous delays. The first thing that the bill does is it creates a CCRC for the Northern Division in the state of Florida. Right now in the Northern Division of Florida, we have registry attorneys, and Justice Quintero, former Supreme Court Justice, both on the bench and since leaving the bench, has said that the quality of those attorneys in the registry is subpar. And that means that there are more errors, more appeals, more trials that have to be sent on remand. So we're going to replace those registry attorneys with professional attorneys who only do death penalty cases. And Mr. Speaker, we're only able to afford to be able to do that because of Chairman McBurney making a priority in his budget. So that's the first thing the bill does. The second thing the bill does is it attacks the types of motions that are most likely to not speak to the guilt or innocence of the accused. I mean, we would always want someone with newly discovered evidence to bring their claims forward and have those claims resolved, but there's a series of motions that are most likely to be frivolous. The first of which is a motion for a new lawyer, because if someone is sentenced to death, they'll often say, well, I have a disagreement with my lawyer because I don't like their purple tie or their three-piece suit, and they'll seek substitution. And in those circumstances, there are excessive delays that don't speak to the guilt or innocence and don't help us resolve these processes. So we increase the standard where if someone wants to substitute their counsel, they have to indicate why the conflict that they have with their lawyers is of such a nature that it would prejudice their rights and it's not hypothetical or speculative. So the next most common frivolous motion that we see that doesn't speak to guilt or innocence are motions for relief as a result of ineffective assistance of counsel. And so the circumstances play out like this. Someone shows up and says, my lawyer at the trial was ineffective. And in the status quo, there's no consequence for that trial lawyer showing up and saying, well, that's right, I was ineffective. So the bill, after two determinations that someone has been ineffective, would bar that person from practice in capital cases for a period of 5 years so that we just don't have these revolving frivolous motions. The next piece of the bill deals with reporting. The House and Senate and Governor will receive reports from the Supreme Court on cases that have lingered for more than 3 years. That way we can determine whether or not there are judges that are not promptly acting. And the final piece of the bill deals with the way that warrants are signed. We have a number of people on death row now who have completely exhausted their appeals. They've gone through the clemency process, and they're just waiting to have warrants signed. These are most often the cases that have lingered for far too many years. And so what our bill says is that after someone has exhausted their state and federal appeals, and after the executive clemency process is concluded, the governor shall sign their death warrant within 30 days for an execution to occur within 180 days. It's very encouraging, Madam Speaker, that parallel to this legislative reform, the Florida Supreme Court has taken a remarkable step and appointed a committee to revise their rules so that we can tighten these substantive restrictions in the law and the Supreme Court can change procedures to ensure that these cases move more quickly. So this is an act of deference to the court while at the same time ensuring that we have a role in delivering justice to the victims. That's the bill, Madam Speaker.